Hello and welcome everyone. Today, we're discussing the key takeaways and practical implications of a landmark judgment delivered by the Bombay High Court in the case of Shiv Charan versus Adjudicating Authority. This ruling clarifies the applicability of Section 32A of the Insolvency and Bankruptcy Code 2016, commonly referred to as the IBC, particularly on the attachment, seizure, and confiscation of assets belonging to a corporate debtor upon the completion of the Corporate Insolvency Resolution Process (CIRP) or liquidation proceedings.
Hi everyone, this is Adimesh. So while this judgment is quite fundamental to the framework of the IBC, as we'll discuss and get to know in a short while, before we delve into the specifics of the judgment, let's rewind a bit and understand the background of Section 32A of the Code.
Absolutely, Adimesh. Before the enactment of Section 32A, there was considerable ambiguity regarding the attachment of a corporate debtor's property by agencies such as the Enforcement Directorate during the moratorium as well as after the approval of a resolution plan. This led to conflicting interpretations by different courts and tribunals, prompting the legislature to introduce Section 32A to indemnify corporate debtors from pre-CIRP liabilities.
That's correct, Shruti. Following the introduction of Section 32A into the Code, the Delhi High Court had held that Section 32A becomes applicable from the date of approval of the resolution plan. This interpretation had provided some clarity on the timeline of applicability of 32A, but with this judgment of the Bombay High Court, we have further clarity on the manner of application of 32A. Shruti, I think we can now delve into the specifics of the judgment.
Sure, Adimesh. I'll begin by sharing the facts of the case at hand. In February 2019, assets of DSK Southern Projects Private Limited, which is the corporate debtor in question, were provisionally attached by the ED under the Prevention of Money Laundering Act 2002, commonly referred to as the PMLA. Subsequently, in August 2019, the adjudicating authority under the PMLA passed an order confirming the attachment of assets. Now fast forward to December 2021, the corporate debtor was admitted into CIRP, and in February 2023, the National Company Law Tribunal, or the NCLT, passed an order approving the resolution plan for the corporate debtor. By way of this order, the ED was also directed to release the assets that were attached by it. However, the ED challenged this directive by filing a writ petition before the Bombay High Court.
Yes, so the Bombay High Court analysed Section 32A alongside the powers of the NCLT under Section 60, subsection 5 of the IBC. I will now try to set out a few points of determination by the Bombay High Court. The Bombay High Court said that Section 32A is a non-obstantive provision and therefore overrides any conflicting statutes. Bombay High Court also said that corporate debtors are automatically discharged from pre-CIRP liabilities under Section 32A, and this becomes effective upon the approval of the resolution plan. Therefore, no actions including attachment, seizure or confiscation can be taken against the property of the corporate debtor once the liability is extinguished under 32A. And also, if there is any question on such an issue of extinguishment of liability and or release of attached assets, the NCLT is duly empowered to decide such questions.
Thank you, Adimesh, for summarizing these key points. So, what I understand from our discussion so far is that in this case, the order of attachment of the ED became void upon the approval of the resolution plan. The properties attached by the ED were automatically released upon the approval of the resolution plan. Now, this in fact aligns with the framework of the IBC because statutory immunity provided under Section 32A is such that there is no requirement neither for the resolution professional nor for the resolution applicant to take any action to quash pending proceedings. But in any case, even if a dispute in this regard arises, the NCLT still has the authority to issue necessary directions against governmental agencies like the ED for the release of attached properties.
That's correct, Shruti. Aptly summed up.
But Adimesh, what do you think are the broader implications of this pronouncement on the overall schemes and the aims and objectives of the IBC?
See, one of the primary objectives behind the introduction of the IBC was to provide an effective mechanism for the recovery of dues through the process of sale of the corporate debtor, but as a going concern. But if the assets of the corporate debtor remain encumbered even after the approval of the resolution plan, it could deter potential acquirers or resolution applicants as termed under the code. This can, as a result, reduce the rate of recovery for the lenders.
So, from what you're saying, this judgment essentially underscores the importance of expeditious completion of the CIRP because there is no requirement to undertake separate proceedings for the release of the property that might have been attached. It also facilitates a clean handover of unencumbered assets to the successful resolution applicant.
Yes, I should agree. But despite the practical hurdles associated with selling encumbered assets via the IBC route, we have seen that governmental agencies like the ED have in the past failed to comply with the legislative mandate of Section 32A.
Right. That is true. But with this judgment, I believe there is much needed clarity on the manner of applicability of Section 32A. And in my opinion, that will definitely boost investor confidence and encourage stressed asset acquirers to participate in the acquisition of distressed assets through the IBC route.
Indeed. That wraps up our discussion for today. Thank you for joining us and remember to join us for our next podcast here.
Until then, take care and goodbye.